Early 16th century, most often cited as the year 1522, the town of Autun in Burgundy, France, faced an absolute catastrophe. A massive swarm of rats had descended upon the region, devouring the province's vital barley crop. But the town fathers didn't just set traps or buy more farm cats to deal with the infestation. Instead, they resorted to the full solemn weight of human jurisprudence, putting the rats on trial before an ecclesiastical court. The rodents were formally charged with the theft and destruction of the harvest, and the bishop's vicar ordered them to appear on a set date. To ensure the proceedings were entirely fair and above board, the court appointed a rising star in the legal profession, a brilliant young jurist named Bartholomew Chasseneuz, to act as the rats' defense attorney. This is the bizarre, historically debated, yet entirely serious story of the man paid to defend a plague of rodents and how humanity once tried to cross-examine nature. To modern eyes, putting animals on trial sounds like a fairy tale, but in medieval and early modern Europe, it was a regular part of Western jurisprudence. The legal system operated under a strict division of labor based on the type of animal involved. If a domestic animal, like a pig, a horse, or a bull, caused physical injury or death to a human being, it was arrested and tried by a secular court. These domestic animals were treated much like human criminals. They were sometimes detained in jails alongside human prisoners. For example, in 1408, a pig accused of murdering a child was kept in a French prison in Pont de l'Arche for weeks. The jailer charged the exact same daily boarding fee, 2 deniers tournois a day, for the pig as he did for the human inmates. If found guilty, these animals were executed by a professional hangman who was sometimes provided with a brand new pair of gloves at the government's expense. This ensured that the executioner came away from killing an animal with, metaphorically at least, clean hands, showing that he incurred no guilt for shedding blood. In 1386, a sow, convicted of killing a child in Falaise, was even dressed in human clothing before being mangled and hanged. But wild animals and swarms of pests like locusts, weevils, or rats could not be physically arrested or thrown into a cell. Therefore, they fell under the jurisdiction of the church. They were tried in ecclesiastical courts where the ultimate punishment wasn't hanging, but anathema and excommunication, a formal curse casting the animals out of the community. The church took these proceedings incredibly seriously, strictly following legal customs and formal procedural rules. When the trial of the rats opened in Autun, the prosecution demanded that the rodents be excommunicated and anathematized for their crimes against the barley harvest. But there was an immediate problem. The appointed trial date arrived, and the rats, unsurprisingly, failed to appear in court. The prosecution likely demanded that the judge issue a ruling against the rodents by default, but Bartholomew Chasseneuz proved that he was going to take his absurd job completely seriously. He stepped forward to defend his client's absence with his first brilliant legal loophole. He argued that the formal summons was legally invalid. Because his clients were widely dispersed and lived in many different locations across several villages, a single summons read in one place would fail to properly notify all of them about the complaint. The law required defendants to be properly informed of the charges against them, and the rats simply hadn't received the message. The ecclesiastical judge considered this argument and agreed with the defense. To correct the procedural error, the court ordered that a second citation be formally read aloud by local priests from the pulpits of every local parish church inhabited by the rats. The legal machinery expanded, forcing clergy across the region to participate in the parade of reading court mandates to empty fields. A new trial date was set to give the rats ample time to respond, but when the second trial date arrived, the courtroom was still empty of rodents. Chasseneuz stepped forward again, successfully arguing that his clients were widely dispersed and needed even more time to prepare for their long journey. After the rats ignored yet another summons, Chasseneuz delivered his masterpiece argument. Chasseneuz explained to the judge that the rats' disobedience was not born of disrespect for the court, but rather from the sheer difficulty and mortal danger of the journey. He reminded the court of a fundamental principle of law. A defendant summoned to a place where he cannot appear safely may lawfully refuse to appear. It was, he argued, the rats' intense fear of the village cats they would inevitably encounter along the way that kept them from fulfilling their legal obligation. The rats, Chasseneuz noted, were very unpopular in the district. They would have to face their natural enemies, the cats, who, moreover, belonged to the plaintiffs. If the prosecution truly wanted his clients to appear, Chasseneuz demanded safe passage. He insisted that the townspeople be required to keep all their cats locked indoors so the rats could travel to the cathedral in peace. The prosecution was completely stumped. They could not possibly enforce a town-wide lockdown of every cat and dog, and the judge was unable to persuade the villagers to comply. Unable to counter Chasseneuz's airtight, unanswerable legal logic, the court adjourned sine die, indefinitely delaying the trial. Judgment for the rats was essentially granted by default, and they were legally safe to continue their barley-chomping ways. If you enjoy discovering the bizarre, forgotten side of history, hit the subscribe button and turn on notifications so you'll know whenever another weird story from the past is posted. This brilliant, deadpan defense supposedly made Chasseneuz a legend, launching his career as one of the leading French jurists of the 16th century. He eventually rose to become the chief judge of the highest court in Provence, but there is a massive glaring catch to this legendary legal victory. In 1531, years after the alleged events in Autun, Chasseneuz published Concilium Primum, a massive, authoritative legal treatise devoted specifically to the procedures for trying and excommunicating insects and animals. It was the definitive manual on the subject, yet, bizarrely, Chasseneuz completely left out any specific mention of his own famous victory defending the rats, omitting the date entirely. The very case that supposedly made him a legal superstar lacked any direct documentation in his own magnum opus. This mysterious omission sparked a bitter, centuries-long feud among historians. The details of the rat trial were actually popularized decades later by the 16th century historian Jacques-Auguste de Thou, drawing on an earlier martyrology by Jean Crespin. De Thou claimed that the story of the rats was true, and that a friend of Chasseneuz later used the exact same legal precedent, the right to safe passage, to try to delay the massacre of a group of human heretics known as the Vaudois. But later historians were highly skeptical. In the 18th century, a scholar named Jean Bouillet mocked the entire story as a beau conte, a beautiful tale, or a myth. Bouillet argued that the story was mere hearsay, pointing to the lack of contemporary evidence and the fact that de Thou wasn't even alive when the trial allegedly occurred. Other scholars, like Barriat Saint-Prix, fiercely pushed back, arguing that de Thou was a reliable source whose own grandfather had been a legal colleague of Chasseneuz. Barriat Saint-Prix also theorized that Chasseneuz left the rat trial out of his book simply because he didn't want to appear boastful while seeking a higher judicial promotion. To this day, scholars still debate whether the trial of the rats of Autun was a brilliant historical reality or an incredibly elaborate and persistent lawyer joke. But whether it actually happened or was merely a popular legend, the story of the rats reveals something profound about the medieval mind. In the pre-scientific era, people lived at the terrifying edge of explanatory darkness. A sudden swarm of pests or a rogue animal could bring immediate death or starvation, seemingly out of nowhere. By arresting pigs and assigning defense lawyers to rodents, our ancestors weren't simply being foolish or superstitious. They were trying to establish cognitive control over a deeply disorderly world. Applying the strict, soaring logic of human jurisprudence to a swarm of hungry rats was their desperate attempt to prove that the universe still had rules.